ladies and gentlemen, our final speaker for today, last but most definitely not least, is a man who's synonymous with the whole question of estate planning. Just for clarification, the will is the foundation of the matter that we're talking about, the will. Estate planning is what happens once we have the will all sorted out in the way that we feel it should be done. Showkat Mukudam has got a BCom honors in taxation, a chartered accountant, a fiduciary practitioner, a founding director of Legacy Fiduciary and Estate Planners, a trustee and deputy chairperson of that iconic institution, the South African National Zakah Fund, for whom he has served more than 40 years of his life. And Showkat will take us through the whole question of, once you have a will, the whole question of estate planning. Showkat Mukudam.
Alhamdulillah Rabbil Alamin wa salatu wa salamu ala ashrafil mursaleen Sayyidina wa Nabiyana Mawlana Muhammadin wa alihi wa sahbihi ajma'in. Respected Shaykh, brothers and sisters and elderly, Assalamu alaikum wa rahmatullahi wa barakatuh. It's indeed a pleasure and honor to be here, I think, on a very vital topic that has been very much neglected over the years. I've been in practice for about just on 13 years in this area, and it's very sad to see the kind of challenges and, quite frankly, as the poster said, families torn apart by proper planning not having taken place, really, from that point of view. So the topic is apt, and I think more should be done in terms of the education through the masajids in this arena, and therefore I actually compliment the Gatesville Masjid today. As you know, in the Quran, there are various, it's a form of codification, and there are various instructions how to perform various acts and pay your zakah and all that. But as Sheikh has alluded, there are many verses that talk about inheritance, many verses that talk about the executor's role in the Quran, and that in itself should spur us to look at this topic a bit more closely. Ultimately, the verses that end up in the final codification of inheritance is, as Sheikh has indicated, in Surah An-Nisa, and that's the final codification. And whether we want to adapt that within a South African situation and improve on it in terms of certain rights and so on, that's fine. But the point is, the essential point is, there is a form of a codification and a process how an estate must be dealt with, as Sheikh has alluded. Sheikh has indicated, you've got assets, you've got liabilities, you've got the concept of wasiya, and then the inheritance goes on between what we call prescribed and residual heirs, really. So the first point I want to make to you is that the Quran is there, the Sunnah of the Prophet ﷺ has related various hadith, again, that Sheikh has quoted, and therefore we should get back to this and contextualize it within a South African context, really, from that point of view. The second point is that I think it's very important that you realize what's happening currently with the process of an estate. No estate takes less than 2 years to completion. Simply because you know what's happening with the government departments, really. 2 is, in many times, there are disputes which delay the estate process. That takes it to 4 years often, really. In some cases, we don't even get out of the starting blocks because there's a dispute at the start point, really, from that point of view, really. So the point is that it takes 2 years at least to get this process and to get heirs the benefits, really. So I think it's very duty-bound on you to make that process as effective and efficient, really, from that point of view. And one of the manners that you really should be considering is to do this restructuring in your lifetime. If you're concerned as sisters that you're only going to get 1/8 of the estate when there are children, then engage your husband and restructure in your lifetime. It's permissible. If you are very clear what you want to give to your children, then restructure it in your lifetime. Seriously consider that, because this estate process is becoming very tedious, very dogmatic, really. People don't answer queries and so on. And at the end of the day, those who are entitled to the heir, to the inheritance, even from the day you pass away, are then denied it almost for 2 years and are deprived of the benefit of that, and that can have damaging effect. I want to put this whole thing together, as the chairperson said. Often when we have these sessions, we talk about the concept of wills, and we concentrate so much of wills, really. But an estate process, an estate plan is much more about a will. I've put, in preparing for this, I've put an acronym together called P.I.G.S. P.I.G.S, for you to remember. Go home and just remember the word P.I.G.S, and you will remember the whole presentation. What does P.I.G.S stand for? P is for a plan. I is for information. C is for communication about your plan. K is about knowledge that you must gain about how its whole process of what does a Sharia inheritance means, what does wasiya mean, effectively. And S is a spiritual dimension to this always, and support to the family who has had the bereavement. So I'm going to cover each of those points for you easily. And you must have heard a lot of these points, but people get so obsessed with just doing a will, and they don't look at the other considerations. Can you believe it? I mean, I was appointed an executor in a relative's estate. I was appointed, believe it or not, 40 years ago, and 40 years later I find out that I'm an executor of my relative's estate, and we see each other every month and so on. Unbelievable, unbelievable that you can go through. So I think that if you look at this P.I.G.S concept, and if you apply these ingredients of the P.I.G.S, you will minimize, there's always challenges in an estate, but the whole idea is to minimize the issues, minimize the disputes. If you see you're going to have a dispute, tackle it whilst you. Do not leave it for the executor as it. So the first point is P for plan, and the most essential plan is a will, effectively, as we know, really. Those of you who have bigger, substantial wealth, we can expand that into a will and a trust and restructuring and all those kind of things. And the essential part of a will is that it must be in writing. Let's start there. 2 is it must be signed properly by the person, the testator, making the will. 3, it must be witnessed properly. Be very clear. No heir can be a witness to a will. No heir can be a witness to a will. Do not make that mistake. More importantly, in a Sharia will that says, I leave my inheritance on a Sharia basis, do not even take your uncle or your brother, whatever the case is, as part of the heirs, as part of the witness, because it's possible. It's possible that they may inherit. Okay? It's possible that they may inherit, depending on the situation when you die. So rather take a total stranger who is not related to you, somebody in a company that does the will for you, or one of your workers. But remember, an heir that is a witness, the will is not invalid. The heir is denied his inheritance. The rest of them will get their inheritance. You can imagine what that's going to create. But that heir is denied his inheritance because you can't be a witness. Those of you who got overseas assets, do separate wills. Do one local, do one overseas. Those of you who are married, do separate wills. Do not do the joint will. From a practical point of view, it's a nightmare. The original will has to be lodged. You can't have certified copies that you're going to keep and you're going to find. Lately, the thing is, the will's disappeared, really. And there was a will, but the will has disappeared. We can't find it, you know. Please put the will in a safe custody place. Because often you move house, you change cupboards, and you move the will, and you can't remember, and the next person can't remember. Leave it with the person who does the will. They will have a will safe, lock it up with a bank, lock it up with a professional person, and so on. And finally, be careful of the free will. You can't imagine that one standard free will apply to all of you here with different circumstances. And what amazes me most is that a lot of people have wealth, but they're not prepared to spend 5,000 Rand seeing a professional to draft and make sure a will is. That can't be the case. You're creating problems. You're really creating problems for yourself, and you then want to say afterwards, how did this happen already from that point of view? So the second point that we talk about under P.I.G.S is information. Any estate process is about information. Don't fool yourself. It's about information. from marriage certificate or antenuptial contract, from IDs that mustn't be lost, right? From the VIN number of the car, from the credit card number, from the investment number. We're not interested in the value. We're interested in who is the money with. Oh, it's with Momentum. What is the account number? Because it's very easy to write to Momentum and say, Mr. X has died, and this is the account number, and what's his balance? All right? We're not interested in the balance. We're interested in the details of the information. Gather this information at least once a year, update it once a year from that point of view. You can't neglect this area and then expect things to be efficient. Information creates a delay in the 2-year process. Remember that. Because by the time we write to Momentum and Momentum does a search and they reply 3 months later. That's how it goes these days, whether you believe it or not. But if you write and say this is the account number and so on, then they'll respond very quickly, effectively, from that point of view. Tax matters is delaying estates like anything. If you're behind with your tax matters, no estate can process until all the liabilities, as you have heard from Sheikh, are determined. And the taxman wants his pound of flesh. And that's a liability in your estate. So if your tax returns haven't been done for 3 years and 4 years, how do you expect somebody to complete your tax return when you're in the grave? You're sitting with all the information, really. Okay? So my sisters especially, push your husbands along these lines and say, where are this set of information? Have a copy of everything. We have on our website, you're welcome to visit our website. We have an electronic document, we call it the personal information, and you can enter all the information electronically, and you can maintain it yourself and keep it yourself, and when something happens, you just use the information. At least update it once a year, really, from that point of view. So the next one is C, and it's communication. Firstly, communicate with your own family to say you have done a will, and they don't need to know exactly what they're going to get, really. But tell them there's a will, there's a Sharia will. If you've got an adopted child, it has a different implication. Okay? It has a different implication. It's not a child from a Sharia inheritance point of view. Make provision for him in the wasiya clause, as Sheikh has given. Because a wasiya you can give to anybody who is not your compulsory, your Quranic heirs, effectively. So you use the wasiya clause for that, really, and give him an amount as you determine, or and work out that the amount is equivalent to what the children would get, but not exceeding a third. So the point is, communicate with your family what the intention is in. And once you see, when you communicate, you're going to see the rufflings. And once you see the rufflings, then you must go into action. Don't leave that problem for the executor. Why do you want to leave that problem for the executor, really? If you see rufflings, then you must handle it, really, from that point of view. And the next part of communication is, please tell the executors that they are the executors in your will. Please tell the guardians, if both of you and husband passed away, please tell the guardians that they are the guardians of the children, effectively, and what their role has to be from that point of view. So the next point is knowledge. As we've now expounded on the issue of knowledge, it's important for you to understand what the Sharia implications is when you say, I leave my assets to be dealt with on a Sharia basis. You need to look at the situation of your family and say, if I die tomorrow, what exactly is going to happen? On many websites, you can work out, you can get the proportions, and we don't need to go into detail, but essentially, the wife gets 1/8 when there are children, she gets 1/4 when there are no children. If the wife dies, the husband gets 1/4 when there are children and a half when there are no children. Careful with this one. When you have only one daughter, only a daughter, she has 50% of the estate. When you have 2 or more daughters, only daughters, no sons, they share 2/3 of the estate. But in that situation, often the uncles and the aunts are part of the inheritance. In other words, the wife will get, say, 1/8, and the daughter will get 50%, and the balance, whatever the balance is, will go to the brother and sister of the deceased. Now, you might not have known that. And you said, I want a Sharia will. Please spend time to to understand what that means vis-a-vis your own family. And remember this, that the ratios and the proportions are determined the moment you die. It's not determined beforehand. You might think what it is going to be, but it's determined the moment you die. So let's give you a practical example. If I have a son, he will get 2-to-1 to my daughter. But if my son predeceases me, dies before me, my daughter gets 50% because she's the only daughter. Do you see how things change? Now, you might have said, I want to leave a Sharia will, okay? But your son is now predeceased. If he's alive, he gets 2-to-1 with the sister. But if he predeceases, look how the ratio changes. Your daughter gets 50%. The mother gets 1/8. The uncles come into play. If, however, the son was alive, the uncles don't come into play because the balance of the estate after the mother gets a 1/8 is shared 2-to-1. The balance is shared 2-to-1 between the son and the daughter. So the point I'm just making is just understand your situation. The final point I just want to make under knowledge is just be very careful that when you have got a predeceased child, in other words, my son has passed away before me or my daughter has passed away before me, it's not automatically that son's children or that daughter's children are going to get a share. Listen to this one very carefully. If you are in a situation where your daughter or your son has predeceased you, died before you, and left children, it's not, they do not step in the shoes of the predeceased child or predeceased daughter, and in most cases, they don't inherit as a compulsory heir. Especially the children from a predeceased daughter doesn't inherit on a compulsory basis. How do you provide for them? Sheikh gave you the answer. You provide for them through the wasiya clause. You provide for them through the wasiya clause. So the clause that we've developed in our wills, which many of you can take, and those of you are practitioners, we say generally, if any of my children have predeceased me, give to that child's children what he would have got as a compulsory heir, providing it doesn't exceed 1/3 through the wasiya clause. So even if you don't have that situation and it arises quickly on you, your will cover that situation because you have got a general clause saying that. We call that a wasiya clause effectively. And it's a very important clause from that. Finally, obviously in knowledge, you also need to know how much taxes are payable, where's the money going to come from, and all those kind of things. If you know, if you have an estate of 7 million rand in your husband, we can make all the taxes eliminated by splitting the estate up between husband and wife, because you only pay above 3.5. So why go pay on 7 when you can give your wife the 3.5 and therefore you pay nothing? Only your family is deprived of an economic benefit. The last point that I want to talk about is the S for spiritual and support. I mean, we've covered the point that the Quran and the Hadith of Prophet ﷺ covers and says why and on what basis and how it should be. I think there's too little communication about this to the family members that inculcates this whole spiritual dimension. Because ultimately, the assets that you have belongs to Allah subhanahu wa ta'ala. When you pass on, it carries on. It's no one's permanent assets really. We're only the custodians, we're only the guardians of those assets really from that point of view. More importantly is the support that the bereaved family must get really. I think it's sometimes very traumatic. You must understand, the executors or the administrators can't be an end of support to the family. Family members have to. Okay? We will do the legalistic work, but when you go back and sleep, your children are not well, they need to go to school, there's no driver to take them to school, the executor doesn't take that kind of responsibility. So often I see that the support structure is just not there. It's just not there. Please do not take it for granted that that's all fine. You and we as family members must ensure that there is a proper support structure, because the deceased spouse goes through such a traumatic experience really. We've got a case now where somebody died very young, the husband died very young, 45 years old, and the children are about 6 and 7, and the wife is totally distraught. I mean, kids need to be taken to schools. For 2 years, there is nothing coming through. I need you to understand that, the danger with it, really. And these children's school fees have to be paid. Simple issues. The insurance of the house has to be paid. Simple issue. If you're not going to have insurance on the house and there's a fire, what's going to happen? Your medical aid has to be there. So one of the issues that we talk about is restructure, place assets on your spouse's hands so that you avoid that situation. Jazakallah, I'm sure there'll be many questions and I'm happy to take.